Hi, good afternoon, everybody. Just a quick recorded version of the presentation we've done many times of a living will versus having a living trust. A lot of people are not aware of the differences, and there are many. At the end of this, we'll have a video with one of the attorneys that we use doing a simple diagram drawing to show the differences. But I want to go through the PowerPoint presentation that we do in person normally. With COVID-19, we've condensed this down to a quick 10-15 minute presentation, kind of a speed dating version, if you will. So bear with me, it will be quite fast, but it's recorded so you can play back the screens. I encourage you to have a pen and paper, make notes, because it's really important stuff. Two of the main pillars of a perfect portfolio include a living trust and then the proper protection in place for the couple, the business owners, etc. So without further ado, let me go through this and quick introduction to myself, Mark Anthony. The Mark Anthony Group. I'm going to go through a disclosure real quick here that we have to display on the screen. Again, it's recorded so you can read that on your own time. Let me move my screen out of the way so you can see some of that, just my company name. Okay. And the difference between having a living trust in place versus not having one, or just a regular will and testament. This example here, Bob's mother, Carol, had a living trust. So all the directives were in place, the power of attorney for any health decisions, the finances, where they would go and how they were allocated. Everything was done to a T. Again, this is a speed version of how we normally set it up in a half an hour, 45-minute presentation. On Tom's situation, there was no directives. There was a will once he passed away, but nothing to kind of like the guidelines if there was a health situation, which there were in Tom's case. So his son John was not able to make any decisions, and we've seen a lot of that come to fruition with the last few months with COVID-19. I hope that can be sorted down the road. If a living trust had been in play, those directives are already built in per the desire of the wording of the person who owns the trust. What else can you avoid if you have a living trust in place? Probate, for one. If you have no plan to protect your assets, your home, your 401k, everything else, it's more than likely it has to go through probate, which means a judge gets involved, an attorney, and more than likely an appraiser. They have to make sure that any debts that are owed, mortgage, credit cards, car payments, private debts, they have a right to be heard, which can take a long time, anywhere from a month if it's quick, up to 2, 3, 4 years. It's insane. And then beneficiary have to wait for that to be sorted out before the estate can be settled. Make sure the finances are in order. Then there's fees involved when it goes through probate, and of course there may be tax implications depending on the estate plan. So the difference between which family are you? Do you have a living trust in place or not? I mean, if you have a living trust, then it's all well and good. It's probably funded correctly and it's done right. You're protected. If you're not, you're going to be in the other situation, which is what we call the government plan, which is not what you want really. Okay, top concerns. Probate, again, we covered that again quite quickly. Healthcare, that may come into play, it may not. And then asset allocations, once something happens to yourself, if it does happen, that's all taken care of in the wording of the trust. The court must verify and enforce your will. That's another thing. If you do have a will, it has to be verified. Everything becomes public record. It's not out of your control, out of the family's control in most instances. And of course, there's those fees. 5 steps to avoid probate. Name the beneficiaries on all accounts. Add the TOD or the POD, we call it, which is transfer of death and payable on death. Use joint tenants with rights of survivorships. Transfer all property to a trust as recommended. Fund the trust. Which is easier than people think. It's just basically changing a checking account into the name of the trust or all the property. It's simply done. We procrastinate a lot in not getting that done, and a lot of the trusts over the years are not even funded correctly, so they're not worth the paper they're written on. Healthcare, will it be there for me? We don't know that. That's everyone's health plan is different. Who will make the decisions? I can't. To have a separate insurance for long-term care. A lot of people don't have that in place. There's a myth that long-term care is covered by health insurance. It's just not in Medicare, not in regular health insurance. Long-term care is a standalone component. The good news is most good insurance carriers nowadays include it as a free rider if it's structured correctly inside of the insurance plan you have. If it's not, that's something I urge you to review and take a look at. It's very important, especially since 2019 in Florida, they allowed long-term care or living benefits to be included inside the term plan. So you might want to look at the one you have and maybe look at changing that one out for the more the 2019 and on plan. Same as income replacement. If you're still working, have a plan in place that covers all the remaining years of income should something happen to you, sickness, health, death. Will my estate be taxed? Again, there's a exemption amount. It doesn't apply to most people right now. It's quite high, but that could change at any time. They might lower that back down to a smaller amount, which means your whole estate net worth could be taxed at 50%. You don't want that to happen. Will taxes deplete inheritance? Maybe so. I mean, that's what you want to protect against again. And what should I do to protect my estate? Call us and set up a living trust for sure. Again, we're just covering that the lifetime giving exemption is 11.4 million when it comes to the whole estate taxes. Not many people qualify for that, but if you do, you might want to look at having something to cover the tax consequence in the estate, and you can do that with life insurance. If you're in a position to donate RMDs to charities, it's something you can look at as well. If you're not aware of the Secure Act that came to pass in December of 2019, that may affect your overall estate. They changed the required minimum distribution to 72. It was 70 and a half. That means it increases the amount of the value of that portion, which means higher taxes. And they've also eliminated the stretch IRA. So if you were passing on to family, they have to now spend that within 10 years to collect, so the government can collect taxes. There are ways around that we can get to on a one-on-one situation, and we can talk about that when we speak to you down the road. Okay, the 5 common mistakes that most people make when it comes to setting up a living trust or converting the living will they have inside of a trust. Procrastination. Start gathering your documents and cataloging the contents of the plan. It's all done for you on a digital format that we use. Trusts that don't avoid probate. I mean, if you have no trust or no documentation, it didn't exist. So it's going to go to probate. The answer to that is to make sure it's digitally recorded inside of the vault that we offer, and there's no way that you can lose a copy of that then. Fire, flood, dog ate it. Without documentation, never existed. Again, go back to the solution, having it inside a digital vault. Not having a durable power of attorney. That's another thing as well. Something happens to either one of you. I mean, right now, those numbers are, I think they're wrong now. That was as of June, July, and moving forward, they keep growing. Having a plan in place for any debilitating medical conditions is key. The living trust has all that included. Plus, it has what we call the pour-over wills inside. Make sure the beneficiaries' destinations are correct. More often than not, we've found that an ex-wife, ex-husband is the beneficiary on a policy. That's not what you want if you've remarried or you have kids, grandkids, or business partners. Make sure it's reviewed and corrected each and every year. So where do we go from here? Okay, the 5 must-haves in your plan: the will, inside of a trust, the healthcare power of attorney, financial power of attorney, and the advanced directives, your words that will carry over in every single segment of the living trust. Start with an estate plan. Ours are fully customized, they're attorney drafted, they're legal in 50 states, they're online digital, they're unlimited changes, no hidden extra fees, everything's included. It's a lot different than it was the days when you had to sit with an attorney and spend $2,000, $3,000, $4,000. Those days are done. It's all done online now. And you can click on the link here. It gives you a 10-day trial with the software that we, with our partner attorney company that we use. We've done the due diligence. We've gone through about 6 or 7 interviews with different companies, and we settled with the state docs. They are the best. That's who we're with. All of our staff that we work with. We recommend that you at least look at the link, and if you don't have a living trust in place, get started. If you have one and it's not been funded correctly, you want to check that. 80% of trusts out there are not worth the paper they're written on because they weren't followed up with having something transitioned into the trust, which means it's worthless. It's a piece of paper. There's my link. If you want to sit down with me for 30 minutes and go over it together, that trial period, we can do that. Just book an appointment on my calendar link and we can get that done. And that's basically it. There's the trial link again, and there's my complimentary link. My details are on there. You can book an appointment with myself or one of my teammates to go over this. We think it's very important that you have the trust implemented, and look forward to speaking with you soon. I'm Coach Mark Anthony, Take care. Hope you enjoy the short, quick tutorial for the living trust versus the standard will. Thank you.